Today I'm going to talk about your rights when you are arrested. But if you're just joining our community, please don't forget to like, comment and subscribe and hit the bell icon so you receive notifications of new videos. Whilst the vast majority of us are law-abiding citizens and we would not deliberately do anything wrong, we all know that feeling of seeing the police either out on the street or behind you in a vehicle, wondering with that pit in your stomach whether you've done anything that you're going to get pulled up for. And dare I say it, many people are arrested for something they genuinely didn't do. So it's important to know what your rights are. But first of all, I think it's important to say that I encourage everybody to be cooperative with the police, regardless of whether you've done anything wrong or not. And nothing in this video should be taken to encourage you to be difficult with the police or to disobey a lawful police instruction. So with that said, let's look at what happens when you are arrested. I'm sure most of you are at least somewhat familiar with the police caution, although many of you may not know what all of it is or what all of it means, so we're going to break it down. The police caution is something that you should be given on arrest and certainly before being questioned in any substantial detail about what you are alleged to have done. So the police caution is as follows. You do not have to say anything, but it may harm your defence if you do not mention when questioned something that you later rely on in court. And anything that you do say may be given in evidence. So let's break this down. The first part, you do not have to say anything. That means exactly what you would think it means. You do not have to answer police questions and provide information in response to their questions as to whatever it is you are alleged to have done, whether or not you've done anything or not. However, the second part of the caution is what makes this really important. The second part goes on to say, it may harm your defence if you do not mention when questioned something that you later rely on in court. So in other words, what this means is, whilst you do not have to answer the police questions, if you do not answer the police questions and provide some information at that first or earliest opportunity, but then you choose to rely on that later in court as part of your defence or as your complete defence, then the court may infer that you've made it up later. In other words, it will be less credible later. And a prosecuting barrister may suggest to the jury that you should have mentioned it and probably would have mentioned it had it been the truth in the first place. And the last part goes on to say, anything you do say may be given in evidence. And again, that's exactly as it sounds. Anything that you do say in your responses to the police questions may be used against you in court. The way this works is if you give one account in interview and you give a different account in court later on, then this discrepancy or inconsistency will be put to you if you choose to give evidence in court, or it will be put to the magistrate or the jury as an inconsistency to say that you've changed your account from interview to something else in court, again affecting your credibility. There are several reasons you are given this caution right at the very outset on arrest. One of them is that it is warning you that if you give an account now and it changes later on, then that may be used against you in court. Similarly, if you're given the opportunity to explain yourself at that first opportunity and you choose not to, again, when you get to court, it might be said that you had the opportunity to explain yourself and you didn't. So if there's a very simple explanation, such as you weren't there, you were with a friend, you didn't do it, or it's not your phone, it's not your car, or any of those kind of things. If you're given the opportunity to explain that right at the outset and you choose not to, then it might be inferred later that you just made it up. Now, whilst the main questions will be put to you in a formal interview, you will almost certainly be cautioned upon arrest as well. That's because anything that you say, anything at all that you say after being cautioned, will become admissible as evidence in court. Likewise, your lack of volunteering of information on questioning as to why you were there or what was happening or whether you were guilty of something or whether you were even involved in something, all of those questions and your lack of response to those questions may be referred to later on. So don't assume that just because police officers are not writing it down physically in front of you at the time, they may write it down later in their pocket notebook to say these are the words spoken by you immediately upon caution at the scene of arrest, and again, that may be used in court. So assume that everything said is written down and accounted for and may be used in court later. And another important thing to note as well, just because the police may give you the caution in a very slightly different way, That doesn't invalidate the caution necessarily. So let's say you've been arrested and you've been cautioned. Now, not always, but almost always, you'll be taken virtually directly to the nearest, most appropriate police station, where upon your arrival, you have three main rights. The first is that you have the right to have somebody informed of your arrest. Also, if you are under the age of 18, you are entitled to have an appropriate adult with you, which might be a parent, a guardian, or someone independently appointed. Secondly, you are entitled to have access to the police codes of practice. These are essentially the rules by which the police must abide. The third right, and one that I say is extremely important, is that you have the right to free and independent legal advice. Now, a lot of people think that they will look guilty if they ask for a solicitor. A lot of people will think the solicitor is part of the police or paid by the police or somehow involved with the police, and this is completely wrong. You have the right to free and independent legal advice. That is exactly what it says. One of the reasons I think this is very important is because if you may think that you are involved in something and therefore you are worried about it, although you may have a valid legal defense, which you might not be aware of, but you might be told about it if you have access to free, independent legal advice. So instead of just sitting down with the police and answering questions and failing to articulate this defense in the appropriate way, you might be causing yourself a lot more trouble. Whereas if you do sit down and avail yourself of independent legal advice, you may be assisted in describing what ultimately might amount to a perfect and valid defense, and therefore set the record straight as to what your defense is at the very first opportunity. Now, if you think back to the caution, anything that you do say may be given in evidence, and if you do not mention when questioned, something you later rely on in court, all of this is so important that if you have a valid defense, it is extremely important to get this right from the very outset. So assuming you are fit and well, and hopefully you availed yourself of the free legal advice, you will then be interviewed. But this must happen within the first 24 hours. Now, apart from exceptional circumstances and really serious cases such as murder and terrorism, the police can only hold you for 24 hours without further authorization in those exceptional circumstances. Now, within that 24 hours, or at the end of that 24 hours, the police must make a choice. So assuming they've interviewed you, they have any evidence that they've managed to gather within that 24 hours, then the police have a choice as to what they can do with you. First of all, obviously, they could release you without charge. They could be satisfied with your answers and your explanation. There could be no other evidence that gives them any reason to suspect or doubt you, and maybe they've just got the wrong person. So they could just release you without charge, and that's the end of the matter. Secondly, they might bail you, but without charging you. This is often referred to as pre-charge bail, and there may well be conditions applied to this. Thirdly, you may just be released under investigation, which means it's not over yet, but there aren't any other conditions applied. And finally, of course, they may choose to charge you, in which case they would have enough evidence, either what they've gathered already or what they've gathered in connection with your interview, and they are satisfied that they can charge you with an offence. So there it is, broadly speaking, those are your rights if you are arrested and taken to a police station. I hope you found this video useful. Don't forget to like, comment, subscribe, and I'll see you next time.